Hi everyone, welcome. Thanks so much for coming along. My name's Madison Dobie and I'm a Senior Associate at Dentons. I'm also a member of the Society of Construction Law Council, so wearing two hats for the next couple of minutes. First of all, with my Dentons hat on, welcome to our offices. It's a pleasure to have everyone here tonight. And we're really happy to host this fantastic evening. The first a couple of health and safety admin notes before we get to the more interesting and fun part. In the event of an earthquake, drop, cover and hold. Please don't exit the building until advised by the Dentons team that it's safe to do so. We've got a couple of bathrooms located in the main hallway, either side of the lifts, so you would have come in with the lifts. Men's are on the left and women's on the right. And I've got that the right way around, but we've got our reception team, Lucy, who is happy to direct you if you need. If there's a fire, the alarms will sound, and please exit through the emergency stairwells located next to the bathrooms in the hallway. If there's a medical emergency, let us know, and the Denton staff team will be happy to, I've got the mic, we'll be happy to assist. So with that, now putting my SCL council member hat on, SCL welcomes everyone for this very celebratory occasion on the SCL calendar. We're delighted to have our two essay prize winners present their essays. We hear it was a wonderful first night in Auckland, and tomorrow night is the last of their presentations in Christchurch. So thank you guys all for coming to share this special occasion with Sean and Daniel. And we've got some bubbles and wine if you want to indulge to honour this celebration of success. Both Sean and Daniel have put a huge amount of work into their presentation, so really appreciate you guys taking the time out of your busy schedules to come and support them. And I'm sure you'll agree that with thought leaders like Sean and Daniel, the future of the industry looks very bright indeed. So also a big welcome to those members joining in the Hamilton Hub. Hopefully they have the link by now and they can hear me, which is being hosted at Pemberton's, and to our online audience and non-member guests, friends, family of Daniel and Sean who are joining us, and our new members here this evening. Before I introduce Sean and Daniel, just a couple of important notices from SCL. On the 18th of September, we have a lunchtime webinar updating members on recent construction law case law, and I am presenting at that. So come along to that. On September the 24th, 25th and 26th, Christchurch, Wellington, Auckland, respectively, Michaela Cook will be discussing construction programming and how the CIOB planning protocol can be easily applied to get a better outcome when writing up construction contracts. Finally, we're really delighted to advise that on the 24th of October, we have a breakfast meeting with the Honourable Chris Pink, who is the Minister for Building and Construction. And this is being held at the Grand Hall Parliamentary Buildings, and love to see as many members there as possible. And we'll be opening up invitations to NZIQS and the like to ensure that we get a full house. So do let us know if there's a specific topic that you would like to have raised with the Minister. So now on to the fun bit this evening. It's with great pleasure that I introduce our 2024 essay prize winners. We will have Daniel first, our second prize winner, and then on to Sean. Ask that you save any questions until the very end, and we'll have the two prize winners join us up front to take any questions and have any discussion that you might have. And reminder that Sean and Daniel's essays are published on the members only area, and their full bios up there too. So it's with great pleasure that I introduce Daniel Maier-Gant, our second prize essay winner, for his essay titled Sharpening the Time Bar, Aligning Time Bar Consequences for Better Enforcement. The judge's citation says, the judges praise the second place winner for their innovation. Daniel identifies a driver of disputes and uncertainty in the sector and proposes a drafting solution. So Daniel is a solicitor at Chapman Tripp and specialises in complex commercial litigation and dispute resolution, with a particular focus on construction and energy disputes. Daniel has appeared as counsel in arbitrations, the District Court and the High Court. So please join me in welcoming Daniel to present today.
Hi, everyone. So I work as a disputes lawyer, which means I spend a lot of time thinking about time bars. And two things I think have really stood out to me in my work with them. The first is that early communication is something that is worth incentivizing. It's very valuable to all parties that are involved. And time bars are often one of the ways in which we put a price tag on having early communication, early notice of disputes, and early engagement with those disputes. The other very important thing is certainty, because when parties come to time bars with very different expectations on how they'll be enforced or what they mean, it's easy to get misalignment. It's easy not to have good compliance with those time bars, and there will be costly, expensive, lengthy disputes at the end of it, where neither party really understands what the outcome is going to be, and they find it very difficult to settle them at a reasonable amount. So what I talk about in this presentation is the ways in which time bars are particularly prone to difficult to predict decisions, and ways in which we might want to, ways in which we might be able to improve that. So what I'll discuss very briefly is firstly the what and why of time bars. What are time bars? Why do parties choose to include them in their contracts? Secondly, I'll look at the ways in which courts and dispute processes in the status quo enforce time bars. I'll look at a real driver of how decision makers come to those decisions, and really it is a very laudable instinct, but one that leads to unpredictable results. It is wanting justice for both of the parties when both have a good claim to what justice is in that instance. And I'll explain why time bars feel unjust to people when they're put at the sticking point of enforcing them. Finally, I'll discuss ways in which we can make time bars fairer and hopefully then sharpen the time bar and make them more predictably enforced. So many people in this room, and I'll just note that time bars are very controversial, will have a view on what time bars achieve and why parties want to put them in. But just at the very basic level, they're a type of limitation clause, which means they govern the ways that parties can dispute and enforce the contracts that they're within. And they play out in a very predictable way, in a very well-understood way across the different types of time bars, in that they have a notification within a certain period from a triggering event. So something happens, and you are required to bring the other party's attention to that issue within a certain period of time if you want to bring a claim. And it operates as a precondition to relief, which means that if you don't bring that notice within a particular period of time, you are not then able to bring a claim in relation to that issue, and you will lose your entitlement to a remedy. They often affect things like extensions of times, defects notice, where there is an event that happens and parties want to incentivize discussing those events as early as possible. So there are a number of benefits to time bars, which are why parties want to include them. And really they all come down to is it is good to understand and engage with issues as early as possible, rather than allowing that issue to kind of go unresolved for a lengthy period of time. So the first major benefit is in evidence. Because if you are trying to litigate a dispute about a site, and it's now the end of the project and you've built a building on top of that site, it's obviously much more difficult to kind of understand what has happened. People's memories have faded, documents have gotten lost, and the site changes. Then just on the discussion and dispute element, often when issues get brought up months, years after the fact, people feel like they're getting blindsided by issues that they had no idea happened. And it's very difficult to build a consensus about what really went on in that instance and try and figure out a way forward. In terms of mitigation, contract breaches and claims about contract are when one party has an obligation under a contract, but then hasn't fulfilled that obligation. So obviously both parties have a role in mitigating those issues, dealing with them, making sure that they then correct that breach so that it doesn't cause ongoing delay. But parties can't mitigate issues if they don't understand that they're happening. And often because contracts are on like very large projects, those projects will have multiple parties, multiple contracts at play, often with their own time bars, their own issues that need to be managed, and parties want early notification of issues so they can pass claims up and down kind of that contractual chain, all the way from subcontractors through the main contractor and up to the principal. And finally, certainty is something that is very valuable if you're trying to finance a project and if you're trying to understand what the risk to that project is. Because if you have more risk and you have less certainty, that means you need to build more contingency into your projects, and that makes those projects overall more expensive and less able to deliver the things we might want them to. So I'm going to give you an example of where, in the ideal world, a time bar has had exactly its intended effect. So we'll see here, just on the 2nd of March, there's an issue that happens at a site, and the time bar starts to run. So the site is the principal's responsibility. They need to deliver a good site, otherwise they're in breach, and any delay that flows from them not giving a good site is their responsibility. And there's a 5-day notice period to raise those issues, and in this case, the contractor has complied. They have given a notice in the form required by the contract. They've said, hey, there's this issue with the site, I need it to be resolved. Luckily, because it's been brought up so early, the principal is able to assess the evidence. Both parties are able to have a discussion about what has gone on. The principal is able to accept responsibility very early and then repair the issue as early as possible. And even if you push out the notice by 5-10 days, those are all extra days of delay that you might be adding to this project because people do not have the opportunity to mitigate those issues. And if you leave it long enough, that might lead to very expensive disputes when neither party really understands what happened when it originally came around. And of course, people might say, Daniel, that's a very idealized version of what happens with time bars. Time bars don't really act like this. And they point to the fact that time bars often favor one party over another party. And while, of course, that is true, many parts of contracts favor one party over another party, and they're part of a broader contract that gets negotiated between the parties. So contracts include things like price, which is very favorable to one party who gets a lot of money given to them, and completion deadlines, which is obviously very favorable to another party who, if someone doesn't deliver you something by a particular date, that then starts incurring harms to them. But time bars are just one of many things that parties are thinking about when they're negotiating the overall balance of contracts. Of course, a rejoinder to this is that sometimes people agree contracts even if they know it's not in their best interest. They allow clauses into contracts even when they know there's going to be something that is harmful to them, or it will be something that is harmful to them, and they aren't able to identify that at the time that they enter these contracts. So there's a range of reasons why parties, yes, might agree to time bars that aren't in their own interests. They might have commercial pressure. There might be a perception in the industry that all of the principals or all of the head contractors are applying the same contracts and same time bars in their contracts, and you don't have any room to negotiate that in or out. There might be some optimism, the idea that if you are faced with a time bar, you are really thinking, well, I'm going to comply with that time bar, so I don't really need to put too much thought into what the consequences of not complying are going to be. That's a very natural kind of human way of pushing issues. Time bars are very abstract. You don't know what you're trading away when you enter into them. You don't know that this is going to be a $3 million claim that you're suddenly at risk of losing down the line. And of course, sometimes there's just errors in assessing risk because people and even lawyers are sometimes not good at understanding contracts and understanding how risks might play out to them. So it's not uncommon for parties to really regret agreeing time bars within their contracts, and often it comes at kind of the sharp end of the time bar when it's being enforced against you and you regret including it in that particular contract. So let's look at how these time bars tend to be enforced across all the different types of dispute resolution procedures from the Court of Appeal downwards all the way to your kind of adjudication. So the headline of this is that time bars are enforceable. They are something that the court has said, look, this is a part of a contract that you have agreed, and therefore we're going to hold you to that bargain. And just recently in 2021, the High Court in KME Services applied a time bar, rejected a bunch of arguments from a subcontractor, and said, look, you signed up to this time bar, and it is going to be enforced against you because you did not give notice in the time that you were required. One thing I will note, though, is even though there's this headline that these time bars get enforced, there are also some rules of interpretation that the courts use to soften the way in which they are applied. So there are two big principles of interpretation that make it difficult to enforce time bars. The first of that is the contra preferential rule. And essentially what this means is that the party that proposes something to be put into a contract, the party that benefits from that term and then seeks to enforce that term against another party, any ambiguity in that term will be, in that contractual term, will be interpreted against you. So it puts things in favor of the party that has not had the benefit of that contractual term and has not recommended it. The second principle of interpretation is that you need very clear words to limit liability for breach of important contractual provisions. So if you are attempting to restrict someone's ability to enforce a contract, the court again will look for any ambiguity within those words and interpret it in favor of the person trying to avoid the time bar. I will note that the courts still say that what they are trying to do here is give effect to the mutual attention of the parties. They're saying this is a way of understanding what the mutual intentions of the parties are. And there's some interesting precedent in New Zealand that the closer you get to exclusion, the harsher these time bars are, the stricter approach we're going to be taking, the more punishment we'll give to ambiguous drafting of these terms. So there's a huge range of ways in which parties will resist time bars and will say that they didn't apply in this particular instance. And I'm not going to read them all out to you, but I'll just note that because there are so many different ways of drafting these clauses, so many circumstances in which they might apply, there are also many ways in which lawyers will argue that the particular time bars don't apply in the instance. They might say that, in fact, we did comply, that we've complied in form rather than function. They might make quite complicated legal arguments about the application of liquidated damages or estoppel or waiver when these time bars aren't applied clearly. But the point I really want to make here is all of these arguments thrive in the within these principles of interpretation that the courts have set down. Because when there's any ambiguity within these clauses, that opens gaps in which these parties will be able to apply these arguments, apply these ways to resist time bars in their favor. So they're really aided by these two principles, contra preferentiam and the requirement for clear language. So what this then ends up being is a very high burden on drafters. And I want to compare the way in which we ordinarily interpret contracts against the way in which the courts have decided that we need to approach time bars. So in the ordinary way of interpreting contracts, we think about the reasonable person and how they would interpret the contractual document in the light of what the parties knew at the time. So you slide your document across the table to this hypothetical reasonable person. You ask them what would they interpret the contract to be meaning in this instance, and then that would be your decision. But when it comes to time bars and limitation clauses in general, it will be assumed that a party will not have intended to limit liability unless clear and unambiguous language is used. So this is quite an exacting standard of clarity we require from drafters to make sure that there's absolutely no ambiguity. And we say that even where a reasonable person would understand the time bar to apply, knowing everything that the parties knew about the contract, if there's any ambiguity, we will discard what that reasonable person would interpret the contract to mean, and we will interpret it in favor of the person seeking to avoid the contract. So that in practice, that's often very difficult to comply with. And you ask yourself, why do decision makers use these interpretive principles? Why are they so harsh on these limitation clauses? And the answer, I think, is a laudable one. Decision makers want fairness, and they want justice between the parties, and they often view limitation clauses as a way for more powerful parties to take advantage of smaller parties. And they seek to protect those smaller parties from kind of a harsh application of contract, and in doing so, they use these interpretive principles. I will note, though, that even where language is clear and unambiguous, that does not mean that necessarily time bars will be enforced. So this is an additional risk to trying to enforce time bars. Even when you've got a time bar, it is as clearly drafted as possible, and the behavior of the people, in your view, fits quite clearly within the ambit of those time bars. Sometimes there are unprincipled decisions that come from decision makers. And I'll note three things that make time bars particularly vulnerable to this type of interpretive, unprincipled decision making. So the first is that the contractual language within these time bars and the fact patterns they apply to are often very unique. There's so many different ways you can draft these time bars, and there's so many different instances in which they might play out. And that makes it very difficult to pick up a Court of Appeal case and say, hey, this has the same time bar, the same facts, this is the way that it was interpreted. There's not a lot of guidance because of how unique often these contractual provisions and these circumstances are. The second factor is the fact that interpretative rules, the contra preferentum rule and the requirement for clear language, are themselves quite imprecise. The court will say we don't want a strained interpretation. We still want an interpretation that is reasonable, but there's no bright line between a strained and an unstrained interpretation. And the English language is kind of dizzyingly flexible. People can make of words what they will. And that means that there's a lot of room for you to move if you are a decision maker in how you interpret these clauses. And the final factor is that often in the construction industry, we use private decision-making bodies. And there are many reasons why private decision-making bodies are excellent, but they do limit accountability. Everything is confidential. There are very limited appeals rights. There's no generation of precedent about these issues. And if you are an individual going to an arbitrator or going to an adjudicator, you don't know how they have ruled on similar time bars in the past, and you have very little ability to predict how they're going to do it in the future. So even though justice is still the thing that motivates these unprincipled decisions, it makes it particularly hard for parties to predict what the outcome of their time bar is going to be when it comes to trying to enforce them. And there are very real costs to this unpredictability in enforcing time bars. The first, and some people will say, no, Daniel, this is a win. We use fewer time bars. And the fact that parties are agreeing these time bars, the fact that there's a mutual intention to bind yourself to good communication, in many ways is a proxy for mutual benefit. Parties saying, we want to be able to discuss things early. We want to negotiate on those concessions. And so we know that we're going to be able to comply with rigorous time bars. We're going to be able to extract concessions for that. You lose your ability to do that. You have a reduced incentive for early engagement and reduced kind of trade-offs in negotiation that happen. But the second really bad problem is that you get misalignment between the parties. And I'll bring you again to kind of a timeline of how a couple of disputes around time bars might play out, where different parties face the unpredictability of decision-making in ways that harm them. So this is the same example as before. In March, there was a slight issue, but this time there's no notice. So the contractor only notified several months later that there's an issue. The parties have fallen into entrenched positions on whose fault it is. It's difficult to find out whose fault it actually is, and so litigation begins. And in this case, there's a 50-50 chance that it will be enforced and won't be enforced, but both parties' lawyers are saying, no, you've got a great time bar, it will be enforced. No, we think there are holes in this, we think we can get away with it. And so this litigation begins, and a huge amount of money is pumped into lawyers' fees, adjudicators' fees, and arbitrators' fees. And in this case, the contractor wins, so the time bar is not applied. Let's look at how the two parties then react to that. For the principal, they might start a new development, but they've had a really negative experience with time bars. It hasn't been enforced, and they therefore have to put more contingency into their projects. They don't offer extra margin to contractors, and that's a loss for them because they don't have certainty of early communication, but it's also a loss for the people who they might be willing to contract with on that basis. As for the contractor, they've had a very good experience with time bars. Because there's so many things going on at the moment, they don't invest in their notification procedures. And the next time they don't comply with the time bar, this time they might lose the 50-50 poll. And then they're stung with a huge liability that they otherwise didn't expect was coming. And they have to go through the whole expensive litigation process again in order to get to that negative result. So that is a bad outcome for both of the parties, but it's really driven by this question of what is justice when it comes to time bars. And both parties have very plausible claims to requesting justice from a decision maker. Because one party wants the justice of the contract as it was signed. It's two parties have come to a contract and agreed, we will be applying time bars. You didn't comply, and that means that you aren't able to access your claim. But the other party says, well, you have wronged me. You are the one who has breached the contracts in a more material way, and simply because I gave notice one day late, you are now saying I lose everything. That also doesn't seem fair. And different decision makers will have different instincts of what justice means in this case. But the fact that we can't predict which way they're going to go poses a really big problem for both of the parties. So the question remains, how do we protect time bars? How do we make them more predictably enforceable? And this is what I think the core problem of time bars is. You have, on the one hand, on the first day, you have your whole claim. You're considering your claim, you think you've been wronged, and you're willing to bring it. You, regrettably, wait until tomorrow to check whether your contract has a time bar. And in doing so, you allow your claim to expire. And then suddenly the next day, you've gone from having an entire claim, you've been one day late, there's no real difference to the contractor whether they receive their notice on day 20 or day 21, but suddenly you have nothing. And this is a cliff that an adjudicator now has to decide whether or not they're going to allow a small interpretative change through to make sure that date is pushed out one day further to avoid depriving someone of their entire claim from simply being one day late in a contract. And the change that I propose in my essay is just changing the ways in which these time bars operate so that there's not a sudden cliff that adjudicators have to bend backwards to avoid. And instead of just allowing that cliff to exist, instead we should discount claims based on how long a party has failed to provide notice. And many people will be familiar with this type of setup. It matches very clearly what we do with liquidated damages, where we recognize having your project delivered 10 days late is different to having your project delivered 20 days late. It is much more expensive to you. And in the same way, having notice 20 days there's very little difference between that and having your notice in 21 days, but there's a massive difference in then getting notice 6 months, 7 months, 8 months, a year down the track. So there's a couple of quite helpful benefits to creating your time bars in this vein. The first is that, most importantly, you align the consequences of not complying with that time bar with the consequences for the other party. You say, hey, you have deprived them of notice for over a month. It is just in this case that you lose half of your claim, as opposed to being one day late and losing everything. The second important benefit is that it allows contractors to think in a better late than never kind of approach, which means that if you are just a couple of days late and your lawyer is advising you, look, there's very little you can do now in terms of complying with that time bar, let's just deal with it at the end of the project. That is something that increases the harm to the principal or to the main contractor who really wants early notice. And this corrects this, because giving your notice one day late is immensely better than giving it after a month or 2 months or at the end of the project. It's a very easy program to customize and apply, because you can just change the numbers and change the dates depending on, for instance, what your funding schedule requires when you need certainty about issues. And when you are a decision maker, all you need to do is come to your decision and then apply a discount at the very end of that process. So it's very easy for parties to include and very easy for them to then apply. And it also forces certainty. It makes parties think about what should be included in time bars and what are just outcomes for failing to give notice in a timely manner, rather than leaving that to ambiguity, which again drives expensive disputes and litigation. But the overwhelming, the kind of highest benefit, in my view, is it leads to better and predictable enforcement. Because decision makers do really want justice between these parties, but they have vastly different views on what justice might mean. And because of the interpretative rules we use, it's very different to figure out what your adjudicator or your arbitrator is going to do. And if we align the gradual nature of the loss with a new gradual nature of these time bars, you are much more likely to have an outcome that feels to all parties as it is fair, and make sure that when you get really big claims, there's an added incentive to make sure that you comply early, as opposed to smaller claims where you might not need that same amount of interest. So those are my thoughts on time bars. Thank you very much for listening, and I look forward to Sean's presentation.
So much for that, Daniel. So as I said, at the end we'll do questions, because you certainly picked a controversial topic. So now we're going to move on to Sean's presentation. So Sean is a member of the team here at Dentons in the construction and major projects team based up in Auckland. The name of his presentation is How Design, Bid, Build, Procurement Undermines the Use of Digital Replicas. And the judges said about Sean's essay, the judges commend the winning essay as a well-researched and structured exploration of an interesting and current topic. A little bit about Sean. As I said, he's part of our team. After graduating in 2023 with the LLB and BSc in statistics, he moved to Auckland from Napier. And Sean says he looks forward to some non-legal perspectives on the issues he raises in his essay. So please join me in welcoming Sean to present his essay.
Thanks, Madison.
Do I need to do something here?
Thanks, Sam. I'll just check that it's working. No, looks all good.
Do it.
Hi everyone, thanks for coming. Today I'm going to give you a brief overview of my essay. And I'm going to start out by discussing what some of you might be wondering, which is what is a digital replica? In that process, I'll also explore a few of the key benefits that digital replicas bring to projects. I'll then move on to discuss the gap that exists between the use of replicas in the design phase of projects and their use in the later phases of projects. Then I'll look at the design, bid, build, procurement model and explore how the limits it places on coordination and protection of intellectual property limit the use of replicas at the later phases of projects. And finally, I'll talk about one way in which we can change prevailing models of procurement to promote the use of digital replicas. So to start out with, what is a digital replica? In my essay, after an unexpected amount of research, I defined a digital replica as any digital representation of the physical and functional characteristics of a building or structure. And that may sound slightly abstract, but it essentially means that whenever I say a digital replica, think of a digital version of a building. The reason I adopted such a broad definition and needed to do so much research was that there are a few overlapping technologies associated with this idea. Some of these include computer-aided modeling, or CAD, CAD, building information modeling, or BIM, BIM, and digital twinning is also a sort of buzz term that has come up recently to describe a similar technology. Many of these technologies are used together on a project that involve a digital replica, and I chose a definition that to capture them all because they are all managed similarly on a project. Having said that, it is worth bearing in mind that CAD and BIM are the most frequently used in New Zealand, and for the most part, I will be discussing the application of BIM to projects since it is the technology that currently is best placed to bring significant benefits to the construction industry. And when we think about the benefits that a digital replica can bring to a project, it is worth taking a step back and considering the idea of replicating a building generally. Scale models of buildings have been used for a long time before computers were invented. And an example I gave of this is the designer of St. Paul's Cathedral in London, Sir Christopher Wren, presenting an initial design of the cathedral to the king. The king's advisors rejected the model for not being stately enough. And Wren went back to the drawing board and produced the design that we see today. The model of the cathedral saved the king an enormous sum by identifying design changes at the design phase of a project and before construction of the real cathedral had begun. The usefulness of a digital replica is very similar to that of Wren's model. Digital replicas allow designers, builders, and owners to see what a building will look like and how it can be built before any building work actually takes place. The key difference with a digital replica is that they are much more precise and can contain much more information than a physical model. For a digital replica to achieve this precision, it is crucial that the information contained in the replica is cohesive. This need for information control is highlighted by guidelines like the New Zealand BIM Handbook, which sets out processes to achieve a consistent structure of information in a replica and a clearly defined purpose from the outset of a project. A replica that achieves this consistency has many advantages. One of the key issues for a digital replica, and one of the key uses for it, is in the detection of clashes. For example, if there's a piece of structural steel colliding with an element of the facade, that clash can be detected at an early stage and redesigned. There are also more technical types of clashes, and detecting these often requires input from not only designers, but also the contractor who will be carrying out the work. For example, with their expertise, a contractor can detect situations where the way building works are programmed or the order in which openings are installed can mean that access to certain areas of the building will not be possible with the current program. These clashes are very costly and require major delays, redesigns, and resequencing on site if they go undetected. On some projects, the clash detection enabled by comprehensive BIM modeling has allowed a saving of up to 20% of contract value. Other benefits of digital replicas during the construction phase are that information about quantities of materials can be incorporated into the replica, increasing the accuracy and speed of quantity estimates. Recently, developers in Korea designed an AI algorithm, which was applied to a BIM model to accurately predict the cost of a project. And while those results may be difficult to reproduce in New Zealand, it does highlight that digital replicas create an interface through which transformative technologies, such as AI, can be applied to the design and construction processes. In digital replicas, which are focused towards assisting with construction management, information about programming elements and efficient site utilization can be included. However, the many useful and cost-saving applications of replicas at the construction phase of the project are often neglected in New Zealand. In New Zealand, the models for three-dimensional modelling at the design phase of projects are very common and well established. But as can be seen in these survey results, this was a 2021 survey by the BIM Acceleration Committee. The use of BIM drops away substantially at the later construction and maintenance phases of a project. This demonstrates two things. First, that in New Zealand, there is clearly the expertise and technological know-how to use digital replicas, as evidenced by the use of the design phase. Second, that despite the fact that digital replicas can bring significant efficiencies and cost savings to the later phases of a project, they're not being used there as much as during the design phase. It begs the question, what feature of projects in New Zealand is creating barriers to the use of digital replicas at the construction and maintenance phases of projects? For me, the way we procure and contract for projects in New Zealand jumped out. The most commonly used procurement model in New Zealand is the design, bid, build model. In this model, the design and build phases of a project are, in theory, siloed off from each other. Under a design, bid, build model, the coordination of the design phase of a replica before construction begins is straightforward. Where BIM is used, an architect or even a more specialized BIM manager can act as a coordinator of the design side replica. Under this model, the BIM manager and other design consultants will be working as a team and can coordinate to maintain clear information standards for the digital replica. The principal is encouraged to produce a precise design phase replica, as any errors or changes in the design will cause an extra cost later in the project. However, under the same model, where a digital replica is used by a contractor at the construction phase of a project, coordination begins to break down. There are two drivers for this lack of coordination at the construction phase. First is that under a design, bid, build model of procurement, the contractor is engaged long after the design phase replica has been created. It therefore has no input into what information is contained in the model. By the time a digital replica reaches the contractor for use at the construction phase, processes such as site utilization planning, programming, and technical clash detection may have been left out of the replica. The costs of incorporating this type of information into the replica at such a late stage are usually prohibitive. Second is that the contractor has no direct contractual relationship with the principal's design consultants. Once construction begins, design consultants hand over responsibility for the digital replica to the contractor, if they hand the model over at all. This is an issue because the contractor loses access to the significant expertise and knowledge of the BIM manager and other consultants who helped create the digital replica. For example, if the contractor wanted to use a digital replica for quantity surveying, it first has to understand a unique project model, which it has had no previous experience with, and then modify the model to include sufficient information about materials to be useful. This takes time and requires the contractor to either have a substantial in-house expertise or engage external consultants to interpret the digital replica. The process of design, bid, build, procurement, with the contractor only being involved at a later stage of the project, and the structure of contractual relationships under the design, bid, build model, both serve to limit the use of digital replicas at the construction phase. Intellectual property is also a concern under the design, bid, build model. In some ways, digital replicas fit within the build-only IP framework. Where they're used only at the design phase, they contain much the same intellectual property as a conventional design, which is distributed across many plan sheets. But where a digital replica is used at the construction phase of a project, the creation of new intellectual property when a contractor's consultant or subcontractors use their project's digital replica is inevitable. Most build-only contracts do not provide for this creation of intellectual property. For example, NZS 3910 contains a two-way indemnity where the principal and contractor indemnify each other against the breaches of the other. These clauses do not address the rights to management of new intellectual property rights. Further, unlike a traditional design spread across plan sheets, the information contained within a digital replica is much more easily extracted and reused. For example, if a contractor modifies elements in a model produced by the principal's design consultants and produces new intellectual property, the new element will contain both the consultant's intellectual property and the contractor's intellectual property. There is no contract between the contractor and the architect in the build-only relationship, and the build-only contract between the principal and contractor only deals with breaches of existing property rights. If the contractor then goes on to use that element on other projects, the architect's rights are unclear. There is also a question around ownership of the whole model, where a digital replica contains elements produced by several design consultants, contractors, subcontractors, and suppliers. This uncertainty around intellectual property rights can have a chilling effect on the sharing of information in digital replicas by all parties involved in a replica's construction. Both of these concerns around coordination and IP can to some extent be managed within the design bid build model. For example, the principal's BIM manager can be novated to the contractor to give the contractor access to their knowledge and expertise. Early contractor involvement can be used to increase contractor engagement at an early stage of a project. Contracts can also be amended between the contractor and principal so that designers can rely on the principal to enforce their intellectual property rights. However, while these measures may remove some limitations of the design bid build model, they are band-aid solutions to the core problem, which is that the effective use of digital replicas at the construction phase of projects requires continuous collaboration between designers and builders, and design bid build procurement is not equipped to facilitate or encourage this collaboration. More collaborative models of procuring and contracting projects are necessary to enable digital replicas to be delivered effectively at the later phases of projects. The structure of contracts under, for example, a design build contract facilitates the coordination between the contractor and the designers necessary for the effective use of a replica at the construction phase. Under a design build contract, there are still issues around the involvement of a contractor at the early stages of a project. But even if this is lacking, since design consultants are novated to the contractor for the construction phase of a project, this allows the contractor to coordinate design consultants and create a replica which is suitable for the contractor's needs. Design build contracts, for example, NZS 3916/2013, also contain much more comprehensive mechanisms for dealing with the creation of new intellectual property. Since design consultants will also have a direct contract with the contractor, they can be much more comfortable about sharing information since they will have a direct contractual mechanism to define and enforce their intellectual property rights. Models such as alliancing provide further benefits over design bid build. And design build, since usually the alliance will have much greater control over a design from the outset. This allows a digital replica to be created with information useful to all phases of a project. Collaborative contracting also have the added benefit of allowing digital replicas to be used to engineer solutions to problems that are encountered on site. A good example of a collaborative contracting model facilitating the use of digital replicas is the alliancing model used in the City Rail Link project. The Link Alliance maintained very clear data standards for their BIM model from the outset and developed a comprehensive digital replica of the entire project. Having such a developed model allowed them to engineer solutions encountered in an urban environment, such as navigating buried utilities, existing structures, and integrating large amounts of survey data and managing traffic flows. The extensive use of the project digital replica was facilitated by the Alliance model in that case. By providing a single point of reference for project information, the digital replica greatly assisted with the management of a project of high complexity. But despite successful examples like this of digital replicas being enabled by collaborative contracting, the reality is that collaborative models are not the norm in New Zealand. The New Zealand construction industry has long had a love affair with the design, bid, build, procurement model and the associated build-only contract. The preference in New Zealand for this model is due to the short-term cost savings associated with the competitive tendering process, the high degree of cost certainty that can be achieved at the time of contract award, and that the model is well known and understood by the industry and clients. However, in the long term, the use of digital replicas could result in cost savings for nearly every project in New Zealand. The adoption of more collaborative approaches is necessary for this to occur, but it needs to be done in such a way that the barriers to adoption can be overcome. One solution to achieve this is procurement leadership from the public sector. The New Zealand government is a major client in the construction sector, and their procurement practices have a substantial impact on the industry. Central and local government together initiate 67% of infrastructure builds and 34% of non-residential builds. This level of market power can be used by the government to shape industry standards through procurement. However, current government procurement guidance does not strongly advocate for more collaborative approaches. This is despite recognizing the benefits for digital replicas. There are several ways more collaborative models can be encouraged in the public sector. For example, in the United Kingdom, the government has encouraged capability by mandating that publicly funded projects use BIM. Since the mandate in 2011, UK projects have seen large increases in BIM usage, but it is unclear whether this is due to the mandate or simply a natural increase in adoption by the industry. Given that BIM has already seen widespread adoption at the design phase of projects in New Zealand, such a broad mandate would be unnecessary. Another option is a tiered system which could mandate procurement approaches for projects based on project value. For example, minor projects under $1 million could have no mandate. Early contractor involvement could be mandated for projects between $1 and $10 million, and design and build or alliancing could be mandated for higher value projects above $10 million. Such a change could be effected through a comprehensive update to New Zealand government procurement rules, government procurement guidance, and the BIM handbook. Leadership from the private sector could also bring about increasingly collaborative models, though previous attempts such as the Construction Sector Accord have fallen away recently. Unlike the technology-focused mandate used in the UK, a procurement-focused mandate has the advantage of not forcing the use of replicas on projects where it may be impractical to do so. Rather, the mandate would ensure more collaborative contracting models are used, which would naturally encourage the use of replicas at the construction phase by facilitating coordination between design and construction teams and involving the contractor in the design phase development of a project. So to briefly summarize, the adoption of digital replicas at later phases of projects is restricted by the predominant design, bid, build, procurement model. Under this model, contractors are rarely allowed input into the development of a project's digital replica, and the structure of build-only contracting means that principals face difficulties managing replicas beyond the design phase of a project. The disjointed relationships under a build-only contract make management of intellectual property rights difficult, discouraging collaboration and innovation. Procurement leadership from central and local government is one way to address both issues. It can increase industry capability and encourage more collaborative models of procurement and contracting. To unlock the benefits of digital replicas, the industry needs to ensure the effective use of replicas is encouraged, not restricted by procurement models. Changing the way we contract and procure projects in New Zealand may not only facilitate the adoption of digital replicas, but open the door for other transformational technologies to be adopted in the future. Thanks, that's me.
Thanks, Sean. Do you want to pop up here? Well, I'll just check whether there's any questions on Zoom. But first, any questions in the room on either presentation? Hannah.
Hello. Hannah Bryce
I'll
from
just get you to join us for that.
everyone
can hear.
everyone online can hear maybe she too. Hannah Bryce, General Manager of Engagement for the Association of Consulting Engineers. They were both really interesting presentations. Really enjoyed them. I have a lot of questions that I wrote down on my phone. I wasn't texting. The first question, Daniel, was around who should lead the change to the application of time bars being introduced gradually. I think it's an amazing idea. Who should lead it, and is that something that Chapman Tripp's advising their clients going forward?
Chapman Tripp doesn't let me talk to clients yet, so I keep leaving my essay on people's desks and hoping I'll leave it up. Obviously there's many parties who could want to push that forward. So obviously if you're writing a standard form contract, you'll have many good ideas that you want to be kind of looking through. I think there are obvious benefits for both the people who rely on these rely on time bars and people who are wary of time bars who want to do something of this nature. It's a softening. But I think the point that I would make is that if it leads to better enforcement, it's a softening that really helps both parties because they can understand what those consequences will be. They'll make appropriate investments into managing those consequences and the risk of those consequences. And then regardless of whether you want to enforce it or want to avoid it, it'll lead to kind of more just outcomes to make sure that your interests are protected. So either party can recommend it. I have a kind of drafting that you can drop into NZS 3910 in my essay. So if you remember, you can go copy and paste that. Please read it before you put it into context. So give it a solid proof. But yeah, anyone could do it.
Sorry, did you have another question?
We can let the rest of the floor go.
Anyone else want to jump in?
I'll ask one, which is, do you actually think legal drafting can have the effect that you're looking for? Because I guess my query is, or rises from experience, which is good projects run well, regardless of whether you have time bars or not. And if bad projects are going bad, the time bars or the lack of them or the presence of them doesn't seem to make a difference. In other words, I suppose what I'm saying is it a solution to the wrong question, perhaps? And I'm wondering what you think about that.
Well, I definitely don't think it'll solve kind of all of the problems that might exist with enforcement. But I do know that parties spend tens of thousands of dollars litigating disputes. That if they had a clearer view on what the consequence of a time bar would be, that they probably wouldn't spend that money. They'd be able to solve. So even if you're just looking at that kind of first level, how do we make sure that we aren't spending lots of money on disputes when we could otherwise be carrying out the project, then there's a positive benefit. But I would say that, and I think this is maybe what a lot of people underestimate, is that if you take your contract and think projects will be good when they're good and projects will be bad when they're bad, and you kind of put your contract in a box and don't think about it much, that what leads to misalignment between parties that can have enormous consequences down the line. So I think drafting is incredibly important, and having specificity and appropriate mechanisms in those contracts really sets the tone for the project. And when parties forget that the contract is kind of the foundational document of that project, it just opens you up to nasty surprises kind of down the track, because then the litigators get the contract out of the box, and then you have to deal with it in the real dispute world. But obviously, I'm highly influenced being a disputes lawyer by seeing kind of most of my kind of work stories are these projects gone wrong, and I think they go wrong and that are applied through contracts that could always be drafted better. And so if this is a one change that could be made to fix some problems, then that's a change that definitely should be done.
Any questions for Sean on the?
Oh, that's fine.
My steps up. This is good. I'll wait over here.
Yeah. I really just, as Sean and a few for Daniel, but we seem to have covered those. But what do you think the tension is between contracts just talking about drawings and specifications and how you could actually bring a model into the way you contract, and whether that helps you solve the problem?
So is that like a model containing the information?
Yeah, whether the model could be a contract.
Yeah, well, yeah, I mean that's the ultimate goal. It doesn't seem like we're there in New Zealand yet. It seems to be that models are usually provided on a information only basis, and there's not really any liability attached to the models. But I mean, yeah, ultimately, if we develop our, as a country, our modeling capability, that would be like the ideal situation, I think.
We've kept a really good time, so any more questions? We've got some more time.
One more, that's all. It's kind of a lead-on question to Sean around kind of you talked a little bit about the lag of the provision of the model to the constructors. Is there something that the industry should be demanding of their clients to drag that model forward to get rid of that lag? And is there a responsibility of the industry to demand more of the client in that space?
Yes, well, having a sophisticated model, I guess the main barrier to it, I suppose, is just upfront costs of developing that model. And I mean, also with things like early contractor involvement, there is a competitive edge that gets lost in the tendering process, which I think a lot of principals or owners are reluctant to use that for that reason. But yeah, I think it is worthwhile to engage contractors at an early phase, and however we do that, it will increase the usability of the models that are produced. Yeah.
Any other questions on either paper? Sam.
Daniel, what you were talking about made me think of 521, which is sort of it's not the time bar, but it's if you don't notify, it's valued as if it was. I haven't read your paper, so maybe you did consider that. And is the advancement on what's in there, so how does it relate to 521? And then is the change to have the set bands to give the certainty, because 521 just says someone else does evaluation. So there's two parts. Did you consider it, and how does it relate?
No, so I hadn't considered kind of other ways in which you can kind of put incentives that seem less harsh than losing your whole claim. Because another way you could set this up is to just say, look, there should just be a monetary penalty. Just make it like straight like liquidated damages. Every 5 days you're late with a notice, you have to pay us like a lateness fee. So that's one way that you could do it. But what really kind of stuck out to me is that these claims can be any number of sizes. And so if you're like, if someone has a $3 million claim up their sleeve versus a $50,000 claim, you really want there to be a lot more pressure on the person who has a $3 million claim to bring it to you as fast as possible. So that's the reason why I looked at kind of the percentages bands, but obviously you could shift it in any way you want. And one point that was made to me at the Auckland presentation yesterday is that people's funders, one of the real reasons for time bars is people have kind of principles have funding arrangements, and those funding arrangements will be predicated on certain levels of certainty. Otherwise, it becomes much more expensive to access finance. And so you might have a conversation with your funder. Look, what levels of certainty do you need? When do you need that level of certainty? So that we can manage this relationship, and that be how you want to apply that kind of percentage basis. But there's many ways in which you can kind of soften it, but I wanted the softening to kind of reflect the later it goes, the more punishment you get. And the type of model you're talking about is, again, it's still binary. It's still 1 day late incurs the cost, as opposed to increasing the punishment as it goes with time, if I understand it correctly.
I have a question. So, since I have the microphone. So, I mean, the classic concern with time bars from a contractor's perspective is, well, from a project-wide perspective, really, is that if you have a hard time bar, the contractor is in a position where they're going to have to notify for everything under the sun, and it makes it difficult for the parties to really understand where the actual pain points are. And your example sort of relies on the parties coming together to appreciate it's in an ideal world, but the parties coming together and saying, let's deal with this issue. But in practice, often it's sort of the notice gets fired off, it gets put in a drawer and kind of just left to simmer. And it's just to preserve position. So I'm wondering how you see that issue being addressed by your proposal.
Yeah, so I don't know necessarily whether my proposal would have that effect. Obviously, it becomes it is a softening, so it becomes less urgent, and there might be less of an incentive to kind of file everything under the sun. But it's really up to, like, if you want a time bar, you have to be ready for people to bring you information, and it's incumbent on you to resolve that information. And if you want there to be less information, and you want people to only bring you real stuff, where there's a real prospect of litigation, you might want to have a price for that. Like one idea I don't discuss in the essay, it's an entirely different kind of reform, but one thing parties could do is to say, look, if you want to file a notice, it has to be of a certain level of meaning, it has to disclose a certain actual level of risk, and therefore, if you want to file a notice, you should have to pay $1,000. And then obviously, if you want to preserve your position, you're willing to put your money where your mouth is, you want to assign this issue real value, there should be some value to that. But obviously that then has to be taken into account, the overall kind of balance of these contracts. I don't want to suggest that kind of people should really be having to jump through heaps of hoops in order to enforce kind of their contractual rights. But we should really turn our mind to how we kind of set up the incentives behind time bars, because having good communication where you can identify issues, not just have a stream of information, it is really important. But then again, if you're a principal and getting lots of information, hire someone to read all that information. It is now incumbent on you to understand what those problems are, or find another kind of contractual remedy to the issue of too much information.
What's the time? Yeah, we've got a few more minutes. If people had any more questions? No? Okay, cool. I'll just hand over to Ari to stay up there. Or you can sit down if you want.
You can sit down. No, I get the privilege of saying thanks to you both tonight. That was a fantastic seminar. I also just like to say congratulations to Madison on being voted on to council. So, you know, that's really good to have continued Wellington representation. We do have Marge as well. But look, tonight was fascinating. I was just sitting there reflecting on it, and I think you're almost both attacking the same challenge from different ends, you know, which is how do you get certainty in a project, right? From the start, it's how do you provide a model and drawings that let everything be priced and get greater certainty in what the outturn price is, and time bars is an administrative way of dealing with the opposite effect, because we probably haven't given you everything you need to know, but if something comes up, we want to know it, right? And so I think from that point of view, there's some really interesting ideas in there of how we can get greater certainty in projects moving forward. So look, thank you very much, Daniel and Sean. I understand you're getting, either last night in Auckland, we're getting some gifts, or tomorrow night are getting some gifts. But for those of us here, I don't have a gift to give you. Could you join me to say thanks? Round of applause.